Law to present to us on an international cyber duty of care for cyber weapons.
Thank you. There's seats down here if you want to just... I can actually move my bag. I'll do that for my audience. You want to be comfortable. Actually, we were scheduled for an hour, but there was rebellion. So they beat this other team to give their paper. So you can thank them. So Wise was only started in December, and before that I was, I suppose, a cyber law practitioner for the Royal Australian Air Force, and within the cyber squadron. So 21 years of teaching international humanitarian law and practicing in it in the Air Force leaves me still yearning to speak to a bit of cyber warfare, which is why I'm here. So the paper that Jonathan and I wrote speaks to the use of cyber weapons internationally and nationally, and where they come from and whether the people that create them should bear in mind reuse, misuse, appropriation. And that includes nation states that prepare them and, you know, the hooded guy over the keyboard with the matrix running behind. So it can even be, is there a teenager who's clever at playing with his mates, and instead of doing what they call swatting, which is in the middle of wargaming, you got the headset on, you ring the police and you actually send a live SWAT team around to your mate because he's winning or losing. So they do the equivalent of that through a little piece of script and create a little piece of malware. But don't think, because the frontal lobe doesn't form until you're 25, of any further use, misuse or consequences, and should they be held to a duty? I think it's easy to come to the conclusion that a nation state should be held to a duty. For the individual, a little bit more challenging. Right, so cyber weapons. What counts as a cyber weapon? So cyber has a lot of definitions, and it is defined in the Tallinn Manual, which, although not either international law or customary law, a lot of nation states contributed to it. And it once and for all killed the question of whether standing international law, standing international humanitarian law applies in cyberspace, aka the fifth domain, according to the United States Department of Defense. Yeah.
Okay, speaking next on international precedent. So regarding how we propose that we create a duty of care with regards to cyber weapons, we can draw precedent from international customary law and precedents set therein, including such as, say, the Chemical Weapons Convention, nuclear weapons and biological weapons. And it all just links back to what kind of potential harm can a cyber weapon in this day and age cause to you personally, but also to national critical infrastructure, our hospitals, our banks, our military, our various financial systems. And this brings to mind what kind of superfluous harm and unnecessary suffering cyber weapons cause, and how we can relate it to the amount of harm caused by various chemical, biological weapons, and how in this day and age, realistically, we should consider cyber weapons as a weapon of mass destruction.
Thanks, Jono. So, in the international context, I've already mentioned the Tallinn Manual, and when Harold Coe was working for the State Department in the United States, that was around the time this topic of, oh, you know, isn't it all just cowboy territory, cyber wars uncharted, the cyber, it's out there. And he definitively stated on behalf of the United States, no, absolutely not. All of the standard laws apply here. So even though the Geneva Conventions are drafted well before we have our dependence that we currently have on computing, we can apply them. They're not perfect. No law is ever perfect or timely, generally. And certainly for cyber and technology, we know it's going to be retrospective and it's going to continue to be. So I think you rely on the smart application of the laws that exist. And so as a practitioner in the field of humanitarian law, That's how we approached it. That's how Television 1.0, 2.0 have approached it, which is, let's apply some common sense here. Because if all's fair in love and war, then we've got some problems. Now, earlier today, in the plenary session, Bruce Schneier talked to it, and it's been talked about subtly and not so subtly throughout this whole conference, is what does it matter how well nation states play this field when you have BigBrother.com playing it, you know, the Cambridge Analytica thing that came out of the elections. What does the nation state matter at all anymore? Again, the law's not perfect, and for now we're still following the Westphalian system of having nation states. We still have borders and boundaries that we protect, and in fact build up defence forces to protect. So in the nature of how cyber is used, the weaponisation of data was used as a term that came out of the fallout from the election. I think we need to be mindful that there is a body of law that exists. And yes, it can be played with, but fundamentally, in the very construct of how we design cyber weapons, and especially those with the most creative minds and the most money, and perhaps the biggest populations to do it, need to bear in mind things can be repurposed.
So going over some case examples, the first one we would like to bring up is with regards to the April 2016 revelations about the NSA exploits being leaked online by a hacking group called the Shadow Brokers. Now this group did steal about 300 gigabytes of data from the NSA, and the data which was stolen was transformed into the NotPetya ransomware. And as we know, this ransomware has been used by, say, the Chinese hacking group, APT3, between 2016 and 17, where they used tweaked versions of this in their attacks on US allies. NSA cyber weapons were also subsequently appeared during a cyber attack on the US city of Baltimore, just recently in May of this year, where 10,000 government email accounts were targeted by a ransomware attack. And the second example that we have up there is in regards to the CIA Vault 7 leak, whereby about 300 million lines of coding were taken from the CIA's Vault 7 by WikiLeaks and exposed online. And this in turn led to the series of WannaCry ransomware attacks throughout 2017. Analysis.
Right. So, I want to just step back a little moment and talk about warfare generally. So if we go back to, say, the 19th century, where warfare is dealt with on a battlefield, and you march across the battlefield and you pierce your opponent with some kind of implement. Back then, the ratio of fatalities and casualties in combat were about 90 to 10. That is to say, 90% of the casualties of that kind of conflict were combatants, and 10% were the civilians. And so we get better weapons, we kill more people. Some of the weapons aren't very specific. And so we get to the Second World War, and the Geneva Conventions fall out of that, because the humanity of war, the suffering, the unnecessary suffering, we decide that even in something as violent and unpredictable as war, and Clausewitz clearly states that war is one of the most unpredictable states, we have to be held accountable for what weapons we used. So how does World War II end? With a massive atomic release. So a huge amount of firepower instantly ends the war. But was that the right thing to do? Did they do the proper calculation of unnecessary suffering and weighing the combatant against civilian loss? So the laws that exist in humanitarian law exist because as societies we've agreed that no, not everything is fair in love and war. There should be limits. We as societies that subscribe to these limits and the additional protocols. And I want that to be in your brain, because now when we fight kinetic war, the ratio is reversed, and that 90 to 10 is now 90% non-combatant casualties and 10% combatants. So bear that in mind as I now try to introduce you to cyber as a weapon. Now, in my experience as a combatant myself, cyber is an amplifier. It's very rarely a unique, discrete weapon of choice. We will use it along with a campaign. So say, for example, something's about to happen in city X. It might be useful if the mobile tower in that city suddenly goes down 20 minutes before we start a bombing run. That's just a practical use. And we would have done it in the past with electronic warfare, but now we might use the cyber tool. The cyber tool. So we came up with conventions that prevented us having, for example, cluster bombs. Because cluster bombs left unexploded pieces of plastic that looked like toys behind. And we as a society said, that's really bad because after a war, little children pick these things up and die or are maimed, and that's disgusting. What about cyber? So in my example where I've not used cyber weapon alone for warfare, but I've used it as a means to assist in kinetic battle. So I've got this thing that takes out a few mobile phone towers at a specific time. Should I, as the creator of that code, have in mind how it can be repurposed and misused? So that's the context. That it puts a lot on the programmer. It puts a lot on the cyber operator to think about. And that's even in the military context, let alone the context I'm giving you with gamers or bright young children who haven't fully formed their frontal lobe might just creatively produce something without even having a concept of the WannaCry down the road. No, you can.
Okay. So the three reasons that we came up with why we needed to regulate cyber weapons is number one, hold manufacturers and users of these cyber weapons accountable for those damages. So say if you had a country who used a cyber weapon and this caused widespread damage throughout country B. As a result, we could have, say, country B bring country A before the International Court of Justice and have this matter determined there. Second reason is that we determined that it would help regulate the production and spread of cyber weapons as a whole. This is with regards to how intelligence agencies might be better restrained in their imagination of how to spread, how to control the public and how to spread these weapons. And thirdly, facilitate stability in the international order. And this ties back to the point of attribution, where we can't respond if we do not know who attacked us. And as a result, the current state which we are in, we have a lot of uncertainty over attribution. Who attacked us? Was it Russia, China, North Korea? And if we don't have a proper answer to that, we cannot satisfy the just war theory with regards to satisfying our population of our right to respond militarily or through cyber means. All right. So our key recommendations here was, firstly, determine enforcement measures and penalties. For example, the imposition of an order to remediate every affected citizen/nation/business would have a high probative value, and this needs to be debated more within the international community. Secondly, promote the creation of international customary law on cyber weapons use and regulations. So this is premised on, say, not just bringing court cases before the ICJ, but also repurposing existing legal frameworks, such as with the United States, which has laws under the EAR and ITAR to form the basis for an opinio juris concerning the duty of care in relation to cyber weapons. Our third recommendation was to establish an agreed means of attribution. And finally, our fourth reason was to agree on what constitutes prohibited cyber weapons. This may include cyber weapons whose use would by definition produce unnecessary suffering. This would require specifying the nature and effect of these banned cyber weapons.
Yeah, so just before we go to questions, which we will do, we have time for, I want you to think about the attribution side of the cyber weapons, because everything that earlier Jonathan was mentioning, you know, where we're speculating about WannaCry, we're speculating about what NSA produced. No one has 100% attributed. No nation state has either agreed or disagreed that they were responsible. So this is a unique thing. It used to be that I could tell you the difference between a Russian round and an Australian round, and what kind of weapon it came from. And that's still possible. It's still possible. You can tell generally the different scripts from different nations and different languages, but it's a problem. It's a problem. So does it being harder to attribute give you the golden ticket to just doing what you want? And nation states that are already subscribed to the Geneva Conventions and additional protocols will say no. Just because you can't necessarily attribute it, we're playing conduct, we're conducting warfare through these gentlemen's rules, and that's how we agree. And why do we continue to do what other nation states don't? Because, for example, if some of our combatants get taken hostage, prisoners of war, we want them to be treated in accordance with the conventions. So attribution is an ongoing bugbear for all kinds of cyber activity.
Well, we live in a post-truth era, so...
We do. So, yeah.
And we have time for questions. A few questions. So I'll start at the front.
Have you considered, or how do you consider the argument that cyber weapons aren't weapons because they weaponize something else? They don't, you know, a bomb has explosive inside it, that constitutes a weapon with destructive potential, whereas code does not carry destructive potential. It turns something else into a weapon that has the destructive potential.
So the NRA would absolutely love your question.
Great.
And if no one gets the reference, I'm talking about the National Rifle Association in the United States of America, which says the guns don't hurt people. People hurt people. Now, I absolutely accept that cyber creations aren't in and of themselves evil. However, I would argue long and hard and into the late hours, probably gaming, with someone who's creating the code, that you were tasked with it or you decided it had a purpose. And in that, now that comes back to the children who are clever in their backyard and they're creating a piece of script they can't possibly imagine being repurposed.
Like you're arguing it was created with destructive intent, which basically means that you're talking about a weapon.
So, for example, in common criminal law, we have two beautiful Latin expressions, mens rea and actus reus. So the mens rea is the guilty mind. I had the intent to murder poor Professor Warren. Am I not intimidating? 5 for 1 of X Air Force power. So I have the mens rea, and then the actus reus is I leap flailing at him and you're a man. So in that sense, no, it doesn't eventuate. But as I wrote the code to take down his device, which would take down his pacemaker, which I knew there was a foreseeable outcome. But these are a lot of steps, and that's what the law sticks us with, is steps. So I can't wholly swallow the NRA argument, but I accept that it exists. And I also put it to us in the geek world, if I may, include myself in that, please. We know enough to know.
Yeah.
I don't just get paid to write code because it's fun. Someone's paying my tune, and if you're working for a certain enterprise, whether it's government, whether it's private, they've said, I want this and I want it to do that. Now, up to you whether you morally ask the question, what are you going to use it for?
You've got a set of requirements and you have to understand them.
Yeah.
So we're going to go for
Did you
question.
want to add
Sorry.
Sorry, we've got long answers, we're lawyers.
So we're going to go question there, then at the front. So,
Yeah, you basically sort of mentioned this, that cyber weapons are usually used in support of kinetic operations, not as a warfare itself, but it is quite possible that the day will come where a cyber weapon is used as a weapon of war in and of itself. Have you considered that basically under sort of rules of war and rules of engagement, which simplistically say somebody shoots at you, you shoot at them, defining what a combatant is in the terms of a cyber weapon, so that like a cyber weapon can be launched from the comfort of the home country, not the battlefield. Does that mean that that operator is under the rules of war considered an enemy combatant and therefore is not
So, that was my entire proposed PhD thesis. And I didn't plant him there, but I'm going to pay you later. I proposed the PhD thesis while I was in fact a combatant. And I had this thing about combatants do combat. In fact, that was the title of the thesis. Didn't write it. I'm not a doctor. Other people were. And precisely my problem. And that goes with whether we're using cyber on its own as a weapon or whether we're using it in collusion with kinetic. Who is the person creating it? So let's just imagine a state called Legoland, where the coffee costs $35 and that's awesome. And no laughs, they didn't watch the Lego movie, awesome, it's fun. Everything is awesome, everything is cool. Okay, when you put up a team. So in Legoland, we decide that we're going to create some script and we get the people who are really good at creating script to do it because we're going to attack Star Wars land. And so Legoland says to the really clever operators who actually aren't in uniform, but they're really good coders, and we say, look, has to be attribution 0, and we just want to take, it's like an EMP through code. Can you do that? And they're like, yep, give us 3 months. And all the monkeys typing out the Shakespeare, they do it, they achieve it. Non-attributable, it's beautiful, and we deploy it. My argument is that the Legoland civil servants have now forfeited the protection under the Geneva Conventions of every single civil servant for Legoland because they were absolutely part of that armed conflict. There you go. How's that? You didn't think you were going to get an answer, did you? The whole thesis.
Well, we're going to go for the final question, and I'm sure EJ and Jonathan will take questions over afternoon tea. So
one's just a bit of a continuation from that first statement, being how cyber war, it's not all cyber weapons are not necessarily weapons on their own. At the very least, in my opinion, they'd be a means or method of warfare. They're an enhancement technology, so it could, even though it might not be a weapon itself, it would enhance the application of one of them. My question, though, is with the attribution. Do you think the lack of willpower to find attribution is because states want to be able to do what they want without the fear of being attributable to a particular crime?
There's a few answers. How long have we got?
Well, perhaps. I mean, with regard to the recent hack of the Australian Parliament in April, we did get news about just this last month where the ASD did determine relatively quickly, within the space of a few days, that this was from China, but they didn't release it publicly. That was only released by Reuters as a result of a leak from within ASD.
Alleged.
Yeah, that's always alleged.
So this is the thing. So if I'm Legoland and it's taken my monkeys 80 days on a typewriter to create this really great piece of kit, and this piece of kit isn't to attack Star Wars land, but it's to be able to tell everything that comes from Star Wars land. This is a really clever piece of kit, and I can use it once. And once I've used it, everyone can analyse it and they can duplicate it. So when is it important enough for me to use it to attribute? So it's not that maybe a nation state cannot attribute, but it might not be worth revealing your cards at that point.
Yeah.
I do not agree that because it's hard or difficult to attribute that people shouldn't be held accountable where we can add enough pieces together. But I also don't think the instant response should be China. I mean, you know, like they're brilliant, but they're not responsible for everything. You know, but that does seem to be the default position of a lot of, you know, the Western nations.
Well, we've got a little bit more time. We'll just take that last question.
What about the product manufacturers themselves? Products are usually built to the product manufacturer specification. Security is not considered as part of it. So have you considered any of this as part of the law and the implications of it? Because pretty much every product that's out there, every service that's out there, and delivery of these services is pretty much, they're all vulnerable. And in a lot of cases, a lot of organisations falsely represent what they can do and how they can do it and what they can actually deliver.
Yeah, so two things there. One is just the generic lack of standards for people purporting to be cybersecurity specialists, cyber lawyers, anything like that. And that's part of the symptom of this having grown up so fast. Doesn't mean it shouldn't exist. We should be held accountable. And in terms of the manufacture of weapons, so Boeing stick to a bunch of international standards. Even the people that produce the 5.56mm round that goes into standard rifles are held to a bunch of standards for how that round performs. Yeah, so am I missing your point?
No, you're not missing your point. But even if you apply ISO 27001 and 2,
right,
you can be compliant,
yes,
but you're not secure.
Oh yes, yes, absolutely. So it's in practice, and it's part of, so it's almost back to the point where organisations need to really engage their people and make them happy and confident and safe in their workplace, so that they actually feel like partaking in the cybersecurity standards. Because if everyone isn't engaged, that will be your easiest fail.
I would say to you that there's two major problems with it. One is that organisations don't really understand their cyber risk or their risk.
Yep.
Two is that a lot of managers have been in positions for such a long time, and they lie to the board, the CEO and senior managers, and even some of the senior managers do this.
Yes.
And they do so because they get very nice pay packets, and they don't want the truth to be known.
So no, it's easier to tell the board what they want to hear. So there's a small book that was just released recently called Governance in the Digital Era, and it's really little, you can read it very quickly, but it essentially says every board should have a lawyer or a cybersecurity expert on it. And so I was like, oh, awesome, I'm a cybersecurity lawyer, this is great. I'm still waiting for the phone calls. However, that would nail that because it's about accountability.
I was hired by an organisation to implement ISO 27001 and PCI DSS, and I was reporting to a lawyer. The lawyer didn't want security implemented, he wanted someone that would lie.
Then they've got an HR problem. They've got, like,
he was part of the organisation, but he was also one of the major contributors to the organisation.
Okay.
Lawyers are people, fallible.
So please join with me for thanking EJ and Jonathan.